Hello, my name is Michael Tesaro and I've prepared this presentation on unfair contract terms in small business standard form contracts. Now, a bit about myself. I am a competition and consumer lawyer. I've been running my own firm for about 15 years, Tesaro Legal Consulting, provide competition and consumer law advice. I've also provided assistance to a few firms who wanted to review their standard form contracts to ensure they didn't contain any unfair contract terms, so I have some expertise through that work. I previously worked with ACCC as a Director of Enforcement for a number of years. It's fair to say the legislation wasn't in place for unfair contract terms while I was there, so my insights come from my private practice and not from my work at the ACCC. Outlining the presentation, I'll firstly run through what the law is in relation to unfair contract terms in small business standard form contracts, so the current law, and then I'll discuss the proposed amendments to these laws which are likely to be coming in early next year. One thing to understand about the proposed amendments is that there has been a long period of consultation. Firstly, Treasury decided to consult with various industry groups about the proposed changes and then made recommendations to the Commonwealth Government on a number of changes. These recommendations were accepted by the Commonwealth Government, who then took them to each of the state and territory ministers to get their sign-off on the proposed changes, which was obtained some time ago. So all level of governments have agreed on the changes, and there is some draft legislation out for comment at the moment which lists all these particular changes. So I think it's fair to say that barring some major development, the changes as set out in the draft legislation will be coming in. So it's important for businesses to be aware of these changes now. First question is, why was the UCT laws for small business introduced in 2016? And it arose largely out of some ACCC research into the impact of UCTs on small business. And the findings there are summarised. 60% of small businesses experienced unfairness in their terms and conditions. 44% claimed that they'd actually suffered some harm as a result of an unfair term. Small businesses also explained that they really didn't have the time or expertise to review standard form contracts, so they were at a disadvantage. And finally, a statistic which I'm a bit sceptical about, but 30% of small businesses claimed they spent less than 9 minutes reviewing each standard form contract. I'd be surprised if the number was that high, but it does present a picture of a lot of standard form contracts being used and small businesses being disadvantaged by these terms. So how do the laws currently work? The first thing to understand about the laws is there's quite a number of threshold questions which has to be answered before you actually get round to the question of determining whether a term is unfair. The first question is whether it's a standard form contract. The next issue is whether it's being offered to a small business. Then there's contract value thresholds that have to be satisfied. Then there's certain exclusions, both general and specific, which have to be looked at. Then you look at whether it's unfair, the term. You also have to consider whether the term is transparent. And the final step is to look at the whole contract. It's not just a case of looking at terms in isolation. So I'll run through each of these elements now. First question is whether it's a standard form contract, and there's a very simple definition of that, which is a contract that's offered on a take it or leave it basis without any opportunity for negotiation or discussion of the terms. In the US, these are called contracts of adhesion. The legislation sets out a few indicators to determine whether a contract is a standard form contract. It looks at who has most of the bargaining power, whether there's any discussion of terms, whether there's an ability to accept or reject terms or negotiate terms. So all these factors will be relevant to determining whether a contract is a standard form contract. Ultimately, it's not that difficult to question, really, to determine. The next step, after you've got through the first threshold, is whether the standard form contract's been offered to a small business. And the current threshold is that the business employs less than 20 people, including casuals. So that can be a difficult task to try and work out how many people are employed by the business you are contracting with. But as you can see, it's relatively small businesses that are covered. The next step is to see if the statutory value limits are satisfied. So there are two limits at the moment. The first is a $300,000 value for a contract over 1 year, or $1 million value over the contract if it runs for multiple years. So if a contract is worth more than $300,000, it won't be able to be determined as an unfair contract term under legislation, and if the value of the contract is more than $1 million for a multiple year contract, then the legislation does not apply. Then you have to consider whether the term may be excluded under the laws, and there are two ways of looking at this. There's sort of general exclusions and then specific exclusions. The two general exclusions are in relation to the upfront price payable and the subject matter of the contract. So it's not possible to allege that either the upfront price payable or the very subject matter of the contract is an unfair contract term, because that goes to the very essence of the agreement, and there can really be no serious argument that that was not an issue that was contemplated by both parties when they entered into the agreement. The other exclusions are specific ones which relate to Commonwealth, state, territory laws which are required or expressly permitted. Specialist contracts in relation to marine salvage, shipping, carriage of goods, also constitutions of companies and managed schemes. The final area that was previously excluded largely was insurance contracts, but amendments were made which included all of insurance contracts under these laws. Now all the thresholds have been satisfied. The question is whether the term is unfair, and there's a three-step process which has to be undertaken. Each of these elements has to be satisfied for a term to be considered unfair. Firstly, there has to be an assessment of whether the term will create a significant imbalance in the rights and obligations of the parties. So we're not looking at a minor imbalance, we're looking at something that's quite stark, a significant imbalance where one party has significantly more rights than the other party. The second requirement is that the term is not reasonably necessary to protect the legitimate interests of the stronger party. So if a stronger party can point to a term and say that I need that term to protect my legitimate interests, then the term cannot be considered unfair. Finally, the term must have the ability to cause detriment, financial or otherwise. So this isn't saying that it has caused detriment, it just has to have the ability to do that in the context of a negotiation. The final issue to consider is whether the term is transparent. The legislation sets out the various indicators of whether something is transparent, and clearly if something isn't expressed in reasonably plain language or legible or presented clearly, there's going to be further evidence that the term is unfair. And then the final step in the process is to look at the whole contract. So it's not a case of just looking at each term in isolation, but to look at how all the rights and obligations are allocated to each party throughout the contract. Because if there are some terms which benefit one particular party and then other terms that benefit the other party, that needs to be taken in consideration with the final assessment of whether terms are unfair. Now, there's some examples of unfair contracts in the legislation. As you can probably see, there's a strong focus on unilateral terms. So terms that give one party the ability to avoid or limit performance, terminate, vary, assign, renew contracts, change pricing, things like that. But there's also a indication that penalty clauses, which require one party to pay a very large penalty for termination of agreement, will be considered to be unfair. Some further examples of unfair contracts and legislation is where there's terms which seek to reassign the liability for various acts between the parties. So clauses that seek to put a lot of liability on the smaller party could be considered to be unfair, and also ones that change the evidential burden on parties in legal proceedings. A good example of this might be entire agreement clauses, which effectively say that the contract is the only record of the agreement between the parties, despite the fact there may have been extensive pre-contractual representations made. So an entire agreement clause could, where there have been pre-contractual representations, be considered to be an unfair contract term. The ACCC has also provided some guidance as to what it sees will be unfair contract terms. Again, there's a strong focus on unilateral terms, limiting liability, recovering costs unfairly. Also, they've got one at the end there which is somewhat controversial, referring to overly broad restraints of trade clauses. Now moving to the proposed amendments, which, as I said earlier, are very likely to come in early 2022. The five major changes are the change in the small business definition, the removal of the contract value threshold, the creation of a new rebuttal presumption, which has been very controversial, streamlining the powers of the court, and introducing pecuniary penalties. So the first issue is that, as you may recall from earlier, the current threshold is 20 employees. Well, under the new proposed amendments, that's going to be increased to either 100 employees or an income of less than $10 million a year. So as you can see, that's a very large increase in the number of companies that will be considered small businesses for the purposes of this legislation. And that's a fivefold increase in the size of employees. It's going to result in very many more agreements being caught by this legislation. The second change is to just totally remove the contract value threshold. As you recall, the current threshold is $300,000 for a single year contract and $1 million for a multiple year contract. Well, that's totally removed now. It doesn't matter how much the contract is for, it can be caught as long as the small business threshold issue is met. And the rationales for removing the contract threshold were a belief that the current thresholds had been eroded due to inflation, which sounds a bit questionable given how low inflation's been recently. And secondly, that the price was not always known at the beginning of the contract, particularly for multiple year contracts. So that seems like a valid concern. Then there's a rebuttal presumption, which is very controversial, but effectively it says that a contract term will be presumed to be unfair in one set of legal proceedings if a term, that same term or a similar term, has been found to be unfair in a separate set of legal proceedings and the contract was being used in the same industry. So using an example, using banking for example, say Bank A gets taken to court by the ACCC and their terms found to be unfair, and then Bank B is using the same term in their contracts. The ACCC could take legal proceedings against Bank B and they would have to prove that their term was not unfair. Now the thing there is they would have to try and prove that one of the three elements we identified earlier did not apply. So either they didn't have a significant amount of bargaining power compared to the small business consumer, that the term was needed to protect their legitimate interests, or alternatively, the term did not have the capacity to cause detriment. The courts also have more streamlined powers, and it's effectively an ability to make orders to protect people from damage or to injunct conduct where a term has been found to be unfair in a separate proceeding. So it's very interventionist legislation, which effectively says to the court, if you found a term to be unfair in this context, you may be able to give orders to prevent it being used in a different context. You can see there both in terms of orders to prevent or reduce loss or damage, and also injunctions to prevent a term being used in a contract. There's also some further guidance to the court to say what they can't give weight to when determining if a term is unfair. So if there's been some minor negotiation about a term, or a business has been given the opportunity to maybe tick a range of options in a contract, those type of things won't be considered to be a negotiation, which means the contract is not a standard form contract. So these things, courts will not be able to place any weight on these factors in determining whether a contract is a standard form contract. And the big issue here is penalties are going to be introduced. Now, the key thing that you've got to realise is that the government has decided to impose the standard Australian consumer law penalties in relation to breaches of unfair contract term laws. There was an argument that there should be a lower level of penalty for these type of breaches, but the government didn't accept those proposals for various groups, and so the penalties will be $10 million, 3 times the benefit, or 10% of annual turnover, whichever is the highest. So that's a very, very big penalty for unfair contract terms. Just a quick commentary on some of the changes. I guess the main thing to realise is the policy reasons why such significant changes have been decided upon by the government, and that's largely due to representations by the ACCC that businesses weren't being proactive in fixing up their unfair terms and reviewing their contracts. The ACCC has run an enormous amount of cases pursuing companies for unfair contract terms, often very similar terms in different cases against the same parties in the same industries. So there's a strong perception in government that the business hasn't been proactive, and the main reason it hasn't been proactive is because there are no penalties for breaching this provision, only the ability to declare a term void. The changes are likely to be very significant. They're going to result in companies being forced to go through their terms and conditions very rapidly and removing any clauses that are likely to be problematic, and also to be reviewing industry developments to see if another term of another company in their industry has been declared to be unfair. The way the ACCC is going to pursue these matters is going to be interesting, but obviously they're going to be very aggressive in their enforcement of these provisions, particularly now they can get large penalties. But also where they take a successful proceeding against a company, it's inevitable they'll be writing to every other business in that industry, pointing out the case and demanding that similar terms be removed from other businesses' contracts in the same industry, and giving those businesses a short time frame to do so. So people or companies will have an opportunity to remove the terms and conditions after receiving an ultimatum from the ACCC. So I guess my advice on how to respond to the ACCC is to be proactive. Ensure you do properly review your terms and conditions. Look at all the guidance as to the terms that have been found to be unfair in the past. You should remove them from your contracts immediately, and be ready to receive a letter from the ACCC if somebody else in your industry is found to have breached the law, because the ACCC is going to be writing to you very, very quickly and asking you to make changes. So that's all I had on this presentation. Hopefully that's been helpful and provides some guidance as to these new laws. And if you have any questions, feel free to send me an email or give me a call. Bye-bye.